introducing Kersi Porbunderwala to talk about the update of the GDPR.
Thank you very much, my lady. Hello, presentation. So, as we go ahead, let me just start with some introduction to GDPR for the newcomers and also those who are heavily involved in the monitoring issues of GDPR. Now, there needs to be a lubricant in everything that we do. And if you use data privacy, data protection, IT security, and cyber security correctly, you can use GDPR as a lubricant to grease the wheels of your corporate governance, risk management, compliance, and security issues. Because now data privacy, IT security are issues that are here to stay, and they will be going on for quite some time, at least for the near future. Many people thought in the beginning, just a couple of years ago, that GDPR will create some issues with regards to privacy, but then the dust will settle down. Of course, the dust will settle down, but what we see so far is that there are more and more issues coming up. COVID is just one of them, and all of these issues affect the way we implement, monitor, execute data privacy, data protection, and IT security issues in the organization. So it is kind of a never-ending situation that we are in. So what we need to do is we need to address all of the paradoxes that we have in the implementation issues, the monitoring issues of the data privacy and data protection. What is the digital reality of the organization? How do we address this transformation? Because here again, and as somebody mentioned earlier, business will not be the same in future after the COVID, the corona dust has settled down. So we need to address these issues in a completely new and a different way when it comes to the reality, when it comes to the paradox, when it comes to the digitization and so on. So the issue is you have to learn all of these things in order to win it. You have to learn and you have to keep up with the different issues that are being presented as we go along so that you can do something about it. Now, when it comes to GDPR or data privacy and all that, the DPO, the role of the DPO is very important. Even though the DPO, the data protection officer, as per the GDPR mandate, does not have any responsibility, any fixed responsibility. He is just overseeing, he is just guiding, he is just, or she, excuse me, the person is just guiding, overseeing, advising, and so on. No really fixed responsibilities. However, the accountability component is there. And therefore, organizations need really to figure out how they're going to implement, to address the role and the responsibilities in inverted commas about the data protection officer. Because he is kind of the ombudsman who is protecting the rights of the data subjects. And this is where the DPO is kind of an in-between, between management, between the oversight authorities and the data subject, so that he fulfills all of the requirements and at many times conflicting requirements between the data subject, conflicting requirement between the board of the executive management and of course the data protection authorities that will monitor the GDPR compliance. We talked about privacy by design. We talked about privacy by default earlier in Scott's presentation and also responded to a couple of questions. And this is one of the important things that we have learned from GDPR that we also can incorporate in other areas, so that post-COVID, post-corona, when we are implementing new procedures, we make sure that we include compliance or risk or governance or IT security by design, so that in the stages where we develop a product, the stages where we implement an IT system or a program or a procedure or a process, we include the component of compliance by design, so that we don't need to address and monitor and control and test and all of these things continuously. This is where a lot of work is going. This is where a lot of manpower is going. And of course, also this is where a lot of mistakes that happen. So privacy by default is not just a backup for compliance, but it should be able to address these issues. We also talked about demonstrate compliance, and I have seen in the organizations that we visit that a lot of time is spent on documenting how they are going to, how compliance work is done. And this can be considered as also a backup plan, so that when the oversight authorities come knocking on your door and ask for documentation, you can present them with the file. And of course, the file is not a manual file. This is old school. We need to have everything digitized and available, so that they can, on a digitized platform, see how you are documenting, your compliance activities. Another area that is creating huge problems is anonymization or de-identification. This was also one of the questions that we had from the audience earlier. And in the last case where I was involved, the anonymization or the pseudo-anonymization, that was the case, and the de-identification, it became an issue when the data that is anonymized or pseudo-anonymized goes to the third party, and the third party adds on certain requirements that the third party needs in order to complete the processes. Here again are some issues which, at least for several organizations, is something new that you need to address. So in any case, things are happening, and post-COVID, post-corona, it will not be business as usual. So you might as well get your act together, get the ducks in line, so that we can start GDPR phase 2 in a way that will help organizations give the lubricancy, give it the lubricants that is necessary, and there can be some additives in the lubricants. There is, my last job was with ExxonMobil, so I know a little bit about lubricants and the additives that you put on those lubricants, and you can add those additives that you need, that is based on the level of security, level of maturity, and the goals and ambitions that you have. So this was kind of the introduction, because we had some extra time to spend, and I hope you don't mind just getting the. So what we will talk about is the update of the GDPR, data privacy, data protection concerns and issues across the European landscape. And as you're aware, today is the birthday of GDPR, the 2nd anniversary. And this is also where the European Data Protection Board is obligated by law, Article 97, by law, to ensure that there is a recap of what has happened so far. And we have a couple of documents. The next 2 slides is links with 2 documents. One is a document from the 18th of February, which is the contribution of the European Data Protection Board to the evaluation for the GDPR under Article 97. This goes through a whole bunch of issues, areas where the European Data Protection Authority has made a commitment, has done a lot of different things to advise, on the one hand, both the companies, at least the large companies, and advise the 29 data protection authorities all across Europe, and at the same time issue guidance on a lot of areas. So this report contains the tools, the documents, and contribution where the European Data Protection Board used it to evaluate the progress and the circumstances so that they can comply with Article 97. The second document is a rather new document. I believe it was issued last Thursday or last Friday, and that was the European Data Protection Board's annual report. And you will have access to both these links and to both of these reports, and it will give you a number of areas that you can customize and use it for your own compliance in your companies. These are reports with about 30 pages each, and each of those 30 pages contains a lot of information that you can transfer and transform into your organization so that you can customize your goals for the next 2 or 3 years as far as the GDPR improvements are concerned. Again, so that you can use GDPR as a lubricant in your organization. Next. But let's take a few points from the evaluation report. And the European Data Protection Board is quite positive in the way the companies have gone about in implementing the GDPR, and it expresses some concerns, which is also in the report. But contrary to what many people were hoping, it does not recommend any revision of the current legislative text that is on the GDPR. There are many concerns that have been expressed. We have gone through a couple of them, and we have also talked about some of the hierarchy issues, the legislative hierarchy issues that are within the GDPR, because there is a lot of conflict. One of the conflicts we discussed was the HIPAA, the hospital records, the patient records, and how does it happen. Perhaps we will talk about it in the next panel discussion that we have in an hour or so. But going back, the GDPR, so many people will be disappointed that the European Data Protection Board does not recommend any revision based on the 2 years of experience that we have. But it wants to have the e-privacy regulation, the revision of the e-privacy, which the white paper has been there. It's been there now for more than 2 years. It was hoped that it would already be implemented in 2018, and then it was going to be implemented in 2019. But it's still there as a white paper, and it has not gone through the Parliament. And that all depends on the EU Commission, how they're going to take care of it. Because according to the European Data Protection Board, they miss the component of confidentiality in communications so that you can safeguard the privacy of the data subjects. Another point of concern is the international transfers. And as you know, there are few countries in the world that do not yet satisfy the adequacy And we hope, of course, that there is no problem with the UK when they leave the EU, that they also need to start on a adequacy procedure, because the adequacy procedure is quite an elaborate documentation procedure. Last time, the last country that was approved on adequacy was Japan, and it took more than 2 years for the European Commission, or for the administrative work that is done by the European Commission, to approve Japan as having legislation that was adequate enough so that data transfers can be done from the EU to Japan without any problems, without any binding corporate rules, codes of conducts, and model clauses, and lots of other bureaucratic issues that are necessary before you can transfer the data. And here again, there are a number of countries that are knocking on the door of the EU to get the adequacy. Some of the countries have not completely implemented their data privacy and data protection legislation yet, but there are the white papers, or there are the documents that have been tabled in the respective parliaments in order that they can be on the adequate country list. Now, the European Data Protection Board also says that there is no pressing need to bring the existing standard corporate rules or the code of conduct to cover any new data transfer scenarios that may be there. There are multiple data transfer scenarios that need to be addressed, but according to the European Data Protection Board, this should be addressed by the companies itself, and there is no need to add any new standard corporate binding corporate rules in order to address the transfer scenarios that have been addressed by many companies. But they want to have a processor, a data processor to data processor standard corporate rules that would allow for the transfers, so that the data transfers are in compliance with Article 46 of the GDPR. It is a little bit technical to go into it now, but you can address the issues if you are a global organization with multiple companies across the world, where you need to have the processor to processor rules, so that corporate rules, so that you can transfer the data according to Article 46. Next. So let us then go into the details about the transfers of personal data to the third countries. This is what it's about. And we have a number of participants from India, and as they are aware, and we will be talking in the next session with a person, Mr. Gupta, who, as a matter of fact, besides being a partner in the Big Four companies, he is also addressing the issues to the parliamentary committee on the data protection and the data privacy issues that India is going to present. It has already tabled the legislation in the parliament, but like many other parliaments, they have other things to worry about than the new legislation in the current COVID corona environment. So, but we will get to know more about the situation there. And that's important because I have heard several statistics, and it says that perhaps 70–80% of all data transactions occur in India. And therefore, it is quite necessary that the that something happens around these areas, because it does create a lot of bureaucracy and a lot of documents that need to comply with the multiple GDPR articles when it comes to transfer of personal data. But adequacy decisions are an important tool so that we can have a continuous protection of the personal data that is transferred. Because many times, as new situations, as new conditions arises in the data transfers, because this again is a moving target, there is nothing called business as usual when it comes to data transfers. You can have new people, you can have new third parties, you can have new systems to transfer data. And of course, as you are aware, we should never ever transfer any data without the data being encrypted, even though it is an email, because as you know, the criminals are extremely active, and everything that you do online, especially if you are using one of the free tools that we get, Gmail and Hotmail and Facebook, and yeah, there are many free things that are available, and therefore it is open to the general public when you transfer data and you do it without encryption. And again, encryption is not that secure. You need to have a level of encryption which is extremely high. Just a few years ago, we thought that encryption, if you had it, for example, based on prime numbers, could not be cracked. However, situation has changed now, so even encryption based on prime numbers can be cracked within minutes. In the past, it was said that there was not enough computer capacity to crack the encryption based on prime numbers. But things in that area is also changing quite drastically. Therefore, we need to make sure that this moving target called the transfer of personal data from one company to another is intact when it is sent and when it is received. So therefore, some of the things that we need to do is do the independent assessment. And it could be done by third parties, it could be done by internal audit, it could also be done by external audit, but we need independent assessment, and it's more than just once a year situation, but you need independent assessment on a regular basis to strengthen the enforceable rights, the effective redress and safeguard concerns about the data transfers. So just not an independent assessment when it is based on the general implementation that you have on GDPR, but you need to have independent assessment when it comes to effective strengthening of the enforceable rights, effective redress, and the safeguards concerning the data transfers. At the same time, we need to participate in any form for evaluation of the current adequacy decisions that are there, and the adoption of the new decisions that will be there, which emphasizing the needs for all of the documents that are needed to allow the time for a thorough assessment. This is what the European Data Protection Board recommends, and this is a lot of documents that you need, and allow the time for a thorough assessment, which is 2 years at least, based on the last situation. So what are the challenges that the supervisory authorities are experiencing? They are experiencing challenges in the cooperation between the 28 or the 29 supervisory authorities that are there in Europe. Because we talked about the ICO earlier, and if you can see, ICO is a very professional organization who take their jobs extremely seriously, and they have the manpower, they have the capacity, they have the knowledge, they have the professionalism to take care of the GDPR in a manner which is extremely good. But that may not be the case in other countries. Well, we have an international audience, so I don't want to offend anybody. But of course, you can imagine that countries like Bulgaria, Greece, and to a certain extent also, Portugal, these countries were quite slow in implementing GDPR, and the enforcement that they have, the enforcement possibilities that they have with the accountability of the supervisory authorities is much different than, of course, what you have in Germany, which have taken the data protection and data privacy very seriously for the last almost 25 years. So therefore, they have had a lot of head start in the way they address the issues when a company calls them and asks for advice. But that is also the case in many other countries. Again, we don't want to mention too many countries because they are all doing their job as best as they can based on the material, on the mechanisms, on the qualifications, on the number of staff that they have in the organization. So there is a need for consistency mechanisms so that large companies do not do cherry picking and address a particular GDPR or data privacy or IT security issue to an organization that is not completely at par, like the ICO or the German data protection authorities and supervisory authorities and so on. Another challenge is also the patchwork of local national procedures, practices, legislation that has on the cooperation mechanisms between the different data protection or the supervisory authorities. And there can be a number of conflicting areas. As we are aware, there are 52 areas in the GDPR articles where national legislation can decide the child's age is just one of them. Is it 13 years? Is it 16 years? And because there was not any uniform implementation and the national parliaments could decide the age of the child, so it is anywhere between 13 and 16. But this is not necessarily a conflict that has to be addressed. It is just a fact that the child age is either this or that. But there are other national procedures, legislation, especially in the field of labor laws, that create some conflicts when it comes to implementing the data protection in the various companies that has multiple companies in many countries. So the goal is that somehow after the second year is gone, so from the 26th, from tomorrow, there is a cooperation between the data protection authorities that somehow result in a common data protection culture. This is a goal. It can be very difficult to implement in the EU because, the North and the South disagree on most issues of the EU. Currently, we have also issues in the EU when it comes to the amount of money that the countries need in order to address the corona issues. And there again, the north of Europe, from Germany, Holland, and Scandinavia, and the south of Europe have conflicting views on how this has to be addressed. And the same is the situation between the decisions that are made from the data protection authorities of the various countries. And therefore, somehow we need to ensure that there is a common data protection culture and consistent monitoring practices, so that the French authority does not issue guidance which can be in conflict with another country, because the global organizations have their offices, their databases in different European countries, and figure out how you can examine the solutions by having some common applications and having some key concepts that can be taken care of in a uniform way. And this is where the European Data Protection Board has a lot of work to do. And they address 4 different areas that the supervisory authorities need to address. One of the things is the difference in complaint handling procedures. When you complain to a data protection or a supervisory authority, how do they handle the procedure? I have heard different figures, somewhere between 200,000, 400,000, and 600,000 complaints that are pending with the different data protection authorities all over Europe. So you can imagine how, with such a huge backlog, and I'm not sure which of the figures is correct. I don't know if you know that, Christian, which figure is correct, but there is a huge backlog. And some of these complaints are, of course, routine complaints. Some of these complaints are from disgruntled DANs, as they also are called, because they feel that they have been mistreated by an organization and they have the possibility to complain against that particular company. How do you address the different proceedings that you have when you are asked for an advice from the oversight authorities? I can give you an example where we had a situation where we had to write a letter to the oversight authorities and ask them for advice, and we wrote it in such a way that it was kind of general in its approach, the letter. And after a couple of reminders, we got the answer back saying that they could not give us an answer because it was too general. So it was very easy for us to rewrite the letter and express it exactly the way it was. And after a couple of reminders, we got it back that it was too specific, so that they will not give us an exact answer, and they recommended that we contact a lawyer instead. So, this is the situation that is with the supervisory authorities. They have a lot of work cut out for them. Duration of the proceedings and the deadlines and so on. Of course, it sometimes takes a lot of time for them to address an issue. And also it depends, because as you know, if you ask the supervisory authority for guidance and you have only 30 days to respond to the data subject request based on the GDPR, and according to some of the guidance or some of the verdicts from the oversight authorities, they say that the 30 days is not up for discussion. You cannot say that it takes 30 days after you get the guidance from the oversight authorities. The 30-day condition is standard that you have to follow, no matter whether you need to have some additional information in order to respond to this particular data subject request. So there are a number of areas where there are some situations where you can address the deadlines and the way, the duration of the proceedings, etc. But the supervisory authorities must identify and monitor all of the national procedures that hinder the full effectiveness and the cooperation mechanisms, so that we can get harmonization, the harmonization in data privacy, in data protection, in IT and cybersecurity legislation as far as the EU is concerned. And of course, they talk about the resources at member states. Supervisory authorities have insufficient resources to carry out the task. And before GDPR, in certain supervisory authorities, there were just a few people. And in certain cases, in some of the countries, even some of the semi-large countries, there were only 5 or 10 people with the supervisory authorities. And of course, when you have backlogs of several thousand complaints or requests for guidance, the resources need to be taken care of quite drastically. In certain cases, in certain countries, the oversight authorities or the supervisory authorities has even moved their offices a couple of times within the last 2 years, because the resources, the number of people that you need to address the GDPR and the security issues have multiplied quite a lot. One of the good things about the GDPR was the one-stop shop mechanism, so that you can address all of the issues in one oversight authorities and do not need to shop around with multiple supervisory authorities. And here again, there are some individual cases where the supervisory authorities need to put in a lot of time and a lot of effort to comply with the requirement of the one-stop shop procedure. We talked about the complaints, and here is a chart that shows the number of complaints there are. Germany with how much is it? 66,000 complaints since May 2018, and this chart only shows the complaints from May 2018 to November 2019, about 1.5 years, 30th November. And of course, you can see how they go down in size, also depending on the size of the country. Spain is a large country. Netherlands is a much smaller country, but still the information on GDPR rules and the data subjects' rights that needs to be addressed is prevalent in some countries more than the other countries. So this is just a slide for information that you get some kind of a situation. Now, what were the areas that the corrective powers of the supervisory authorities replied to? In this chart, as you can see, we have focused on Article 58, and it's about the warnings. You get a warning, and there has been 1, 2, 3, 4, 5, 6. So less than half of the EU countries had a chance to, or where the supervisory authorities gave warnings to the companies. And warning is, of course, quite a serious thing. And as you are aware, the supervisory authorities have also the power, just like the FDA, to close the shop in case of the warnings that are given are not addressed by the organization, especially when it comes to the data processor levels. However, when it comes to reprimands, there's been multiple reprimands in the various countries. Almost all of the countries are represented there. When it comes to order to comply with data subject requests to exercise the individual rights, where the supervisory authorities have addressed a particular data subject complaint, there again it has been quite a few countries that were given an order to comply with the data subject request without any hindrance, because they got the complaint from the data subject. Order to bring processing operations in compliance. Every country has had that situation. And this is, of course, one of the areas where the supervisory authorities use their corrective powers bring the processing operations into compliance, because one thing the supervisory authorities know extremely well is what is written in the legislation. And I have spoken to a number of different supervisory authorities, and in the course of our GDPR classes all over Europe, we have had several times where the supervisory authority representative talked about the articles, and I can say that every one of them could recite all of the 99 articles in their sleep. I believe sometimes they even dream about those 99 articles because they know them so extremely well. Order to communicate a data breach to the data subject. As you can see, only a third of the countries have had some issues in that particular area, which of course is quite surprising, because data breach, as we know, is something that the companies take very seriously, and therefore it is only a few countries that have had the situation where the supervisory authority had to make the order to the company to say that the data breach was not communicated according to the rules and regulations of the GDPR. So here again, a clear indication that the companies in the EU are taking the data breach and the communication to the data subjects extremely seriously. A good thing that we have managed. Temporary or definitive limitation, including a ban on processing. Very serious thing, a ban on processing, either definitive or temporary or limited. And here again, they had the power and they exercise their power, so that we know that they will take this seriously. And if we get either a temporary or a definitive or a limited ban on processing, that means essentially if you are a data processor, you have to close shop, which can be an extremely serious thing. We continue with the corrective power, and I have focused on the corrective power so that you get a clear indication on where and how and what are the different areas where the supervisory authorities want to focus on. Order of rectification or erasure or restriction of processing and notification to the recipients. Again, erasure is a situation, a thing, a technical component, which many times is not completely compliable for many organizations, for many companies, for a number of different reasons, especially relating to the limited erasure possibility in the legacy systems. And of course, it is not easy to replace a legacy system, an old system that is working in order. And many times it is also very, very difficult to change the legacy systems. And therefore, you need to address the deletion or the erasure procedure when it comes to the data subjects' rights and the data, the personal data, so that it is gone and erased and deleted and burned, you may call it. Withdrawal of certification, order to certification body to withdraw certification or not to issue certification. There has not been any corrective power from the supervisory authorities, and of course there cannot be any power because still we are waiting for the certification guidance from the authorities. It has not been issued. We have now got the ISO standard, ISO 27701 and ISO 27702, which addresses some of the certification issues, but still the jury is out, and probably sometime next year we will get some guidance on the certification issues. Administrative fines. Again, not all of the supervisory authorities have issued administrative fines, and this is an area that will increase as time goes by. Order to suspend data flows to a recipient in a third country. Surprising, here again, the companies are taking GDPR extremely professionally, extremely seriously, so that there has not been a order to suspend data flows to the recipient of a third country. Again, the third time where we can give bravo and kudos to the EU companies for taking the data protection, data privacy, IT security very seriously. And then additional powers under national law, as we talked about earlier, 52 areas where you can have changes in the national law. And here are some of the areas where supervisory authorities, not taking into consideration the GDPR, but taking into consideration the national law, were able to either give an incremental penalty or require additional penalty payments or order a daily penalty if they were not able to resolve the issues in a timely manner, or issue notices of intent, or issue enforcement notices, and so on. So also the additional powers that are given under the GDPR is being used. So finally, we come to the conclusion. Now, I have only taken 10 points. I could have added either 20 or 30, but this is not the time to have a conclusion list that is a checkpoint, but or a checklist. But this is 10 areas that we can look into, so that based on the two reports that I talked about in the first couple of slides, we can figure out how we need to address the data protection, the data privacy, the IT security and cybersecurity issues in a general way. And as we said earlier, we have audience from all over the world, in the approximately 300-400 people that have signed in. Of course, not all of them are going to be there for the whole day. Some of them are, I can see from the list, which is very nice. Thank you very much. But you can also use these conclusion points in your countries, whether it's in South America, or whether it's in Africa or Asia, or other parts of the world, wherever you may be. Why? Because of the fact that GDPR was for EU residents, no matter where in the world they live, and being that data knows no boundaries, and data is being processed all over the world, and databases are also all over the world. So GDPR got a de facto legislation platform that was applicable to countries also outside of the EU. And because of the traditional European respect for citizens, European respect to take care of its own citizens all over the countries, all over Europe, there has been a tradition to protect the human rights of the EU residents. And the human rights of the EU residents is personified with the data protection and data privacy legislation that GDPR is about. So therefore, GDPR now is a global, de facto global gold standard for data protection, data privacy, IT, and cybersecurity. Now, I keep on mentioning IT and cybersecurity when I talk about GDPR, is because I believe that IT security is probably 60, 70, 80% of GDPR. The rest is just formalities that you need to make sure that is included by design in the process. But the real area where you need to address is in the IT and cybersecurity processes or controls. So going back, conclusion, strike the balance between protection and the industrial competitiveness and innovation so that the development of new products and services is not blocked. When GDPR was introduced, or when the white paper was introduced, that must be about 5 years ago, the commissioner at that time, I don't recall who it was, but the commissioner at that time mentioned that when we had the free movement of labor, we increased the GDP by 10 or 12 or 15%. And when they had the free movement of data with the GDPR, they also wished that the GDP of a country would increase. Of course, we have not seen that yet because we have had some crises that have pulled the economy back. First, we had the credit or the financial crisis that we were almost recovering from, and now we have the COVID and the Corona crisis again, which is going to put us back at least a couple of years as far as the economy of the country, the economic richness of the country is concerned. And therefore, there is a distinct desire for the development of new products and services. And of course, we need to balance the data protection and the competitiveness and innovation in such a way that GDPR or the data protection and IT security issues do not block the creation of new services or new products, because otherwise we will be in a very bad shape. Incentivize data protection compliance strategy as a business enabler for data-driven innovation. I have seen many large companies that use data for innovation. And I have also seen large organizations using or having a department where they can have innovation based on data and being a business enabler. So focus on how you can incentivize the data protection compliance and strategy to drive this innovation component. The third point is the Internet of Things, artificial intelligence, big data, and all of these nice things that we're going to have. How will that change the way we are addressing the enforcement challenges? And again, it's not business as usual. And as soon as 5G is introduced all over the world, it's really going to change the data environment in a way that we will probably think back to the old system where we had the analog data and not the current 5G, which will have a speed that is absolutely fascinating. Conflicting data retention schedules on local laws and guidance from the DPA is limited. So whenever there is conflicting data retention schedules, you have to address it in a way that you don't get into trouble. We talked about HIPAA, for example, earlier, where there could be a conflict. And there again, I have discussed with many legal people all over the EU, where many times it is said that the hierarchy where GDPR is placed compared to all of the other laws is quite low. So there are many other laws that are highly rated in the hierarchy of legislation, so that you are aware that, for example, data retention of records is not a big issue. Vigorous enforcement has resulted in further investment in data protection compliance across the country. So get your checkbooks out. As soon as we have the enforcement challenges of artificial intelligence, 5G, IoT, and big data, and so on, it will require some resources and also financial resources. Uncertainty regarding the pseudo-anonymization and anonymization areas is a place that you need to address. I just gave you one example. When you take a pseudo-anonymized data or an anonymized data to the third party, how is that going to affect your GDPR compliance? The data protection authorities must launch consultations parallel with the EDPB, the European Data Protection Board, and the EDPB must take initiatives in this manner so that the consultations are parallel and the enforcement or the advice is uniform. Transparency obligations under Article 13 and 14 have led to overload of information. Also because the transparency obligations under Article 13 and 14 for the data processor especially requires so much documentation that they could spend a lot of time in just documenting the processes and the way they comply with the transparency obligation, that it becomes quite a bureaucratic challenge for the data processors to do that under the Articles 13 and 14. And finally, I have 1 minute left, so we can take the last point, which is the legitimate interest can result in more conscious and protective processing activities. As you're aware, legitimate interest is one of the 6 legal methods of processing data, and legitimate interest was often used in connection with marketing activities or many other activities, also many research activities in the medical industries and others. And there are some areas that you need to, or the data protection authorities need to address as far as the legitimate interest is concerned, so that it can result in a more conscious and a more protective data processing activity in the organization. So that was
Peter. Peter have some questions.
Okay. Well, I think we are now at 2. So it's 2 o'clock, and I have completed my question. There are some questions from the speakers. However, I think we will have a panel discussion in a short while so that we can address that. And the question is a sponsor established in third country subject to EU data protection rules? We will address that. And is it true that under GDPR, personal data must be exclusively stored within Europe? No, it's not true. What are the data protection, right of data portability? Yeah, we did not talk about data portability. It's one of the areas also where the oversight authorities can issue some uniform guidance, because this is an area that will create more, has already created and will create some more issues. Anyway, my time is up. I have used 1 more minute than I was given, even though I started earlier than necessary. So we will now be going into the panel discussion. And my lady, would you like to take over and introduce our panelists, a truly global and international people from Africa, South America, and India?
I will indeed, but Kersi, I'd just like to make one comment, and perhaps later on with further discussions on your excellent presentation. And the point that really comes to my mind, you referred a number of times to the authorities who have the responsibility for enforcement. Can you hear me? Can you hear me all right?
Yes, we can hear you.
And the point being is that COVID has thrown everyone's economies completely out of the window for now, and that will include the resources to be allocated to the enforcement authorities. Are we into a period when the hackers and the like